Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 23CCCR0070. The case is styled the state of Texas versus Drayvon Duhon. Drayvon Duhon. It's 212. Mr. Duhon, your full name is Drayvon?
Yes.
Drayvon Duhon? Mr. Duhon, would you please raise your right hand? Mr. Duhon, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. Again, how are you doing? You're doing fine. That's good. Now, Mr. Duhon, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Duhon, it alleges that on or about April 4th of 2023, while you were in Jefferson County, Texas, that you, Drayvon Duhon, committed the Class A misdemeanor offense of assault, bodily injury of a family member, which is a Class A misdemeanor. Do you understand what you've been charged with?
Yes, sir.
And to discharge Mr. Duhon, how do you plead? Not guilty, guilty, or no contest?
Guilty.
Guilty. Now, are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Okay, now, Mr. Duhon, I also have before me a couple of documents. First document that I have is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Yes.
And is this your signature on the line that is titled Defendant?
Yes, sir.
And are these your initials on the line stating you want to waive your right to an attorney and to represent yourself? I also have a document here that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? Now, I also have before me on this tablet a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials. First set of initials, DD, are on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir.
On the next set of, the next set of initials are located below a paragraph that is titled Discovery Admonishment, and they are on a line next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is that your signature?
Yes.
And the next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Duhon, before you sign and initial all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Duhon, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishments. State, would you like to offer State's Exhibit 1?
Yes, sir.
You have any? Now, the state would like to use this document as evidence in your case. This document is the first document that you said the first document on the tablet that you said that you recognized. This is the same document that had your signatures on the line that's titled guilty and on the line that states that you're waiving your right to discovery. And this document also have your signature on the back of page 3. Is it all right for the state to use this document as evidence in your case? Now, also, Mr. Duhon, you had a right to have a court reporter to dictate everything that's being said. Now, you can waive or give up that right. And do you waive or give up that right? Okay. Now, let's see. State's exhibit number 1 will be admitted. Mr. Duhon, is there any evidence that you are currently mentally incompetent to stand trial? Okay. Mr. Duhon, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for a plea of guilty no contest, the state's agreed to offer 1 year deferred adjudication, community supervision, $500 fine, court costs, 60 hours community-based service, attend and complete of the batter's intervention prevention program, and all other standard terms and conditions of probation.
Okay.
Now that generally in these cases, Judge, we have a no contact part of this. However, the defendant and the complaining witness have a child together, so therefore we're not going to place that as a condition of probation.
Okay.
So that they can raise their child.
Okay. Now, Mr. Duhon, the state is offering that you serve, that you be placed on probation, deferred adjudicated probation for 1 year. During that 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $345. You will also be required to pay a probation fee of $60 each month, or your analysis fee of $15 each month, and a reimbursement fee of $15. Your total monthly installments, that is, the total amount that you will be required to pay each month while you are on probation. Hold on a minute. Is $160 a month. Will you be able to pay the $160 each month?
I'm already paying on a couple of things. You think I can lower you now?
Okay, so you're saying that you're unable to pay it, the $160. Okay, let me do this. Let's see this. Okay. Now, Mr. Duhon, your fine and court cost is going to be converted to 68 hours of community service. Okay. And the probation fee is going to be lowered to the statutory minimum of $25. Now, I have an affidavit of indigence that you had previously filled out, and I'm basing it off that information, the income that you have, that you state that you're getting per month. Yeah, and you have 1 child. Yeah, so let me just repeat. Now, the state is offering that you be placed on probation, deferred adjudicated probation for 1 year. During the 1-year probationary period, the $500 fine plus $345 of court costs, which is $845, is going to be converted to 68 hours of community service. You'll be required to also pay the statutory minimum probation fee of $25. Now, you'll still be required to pay the $15 year analysis fee and the $15 reimbursement fee. Do you understand that? Now, you will also be required to perform 60 hours of community service. So in essence, you'll be required to perform 128 hours of community service, because 68 hours is going to be the fine and court cost that's converted to community service. And then you're going to have your regular 60 hours of community service. Do you understand that? Now, you will also be required to attend and complete the Batters Intervention Prevention. Yeah, the Batters Intervention Prevention Program. We call it BIP. And you'll also be required to adhere to the other standard conditions of your probation. Now, do you understand the state's offer and the court's adjustment that the court is making? The court is finding that you're indigent. And that finding of indigency is pursuant to Article 42.15 of the Texas Code of Criminal Procedure. Now, do you think that the state's offer and the court's finding is fair and just? And do you accept it? Okay. Now, Mr. Duhon, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Duhon, if you successfully complete this program, this probationary period, this case will be dismissed. It will not result in a conviction in your record, and you may qualify for a non-disclosure. You can talk to an attorney about the non-disclosure. Now, you should have another document before you. I'll go over this document, which is titled Modern Written Admonition on Ineligibility to Possess a Firearm or Ammunition. So in accordance with the Texas Administrative Code, Section 176.1, the court hereby admonishes you of the following. Number one, you are by entry or order or judgment ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code Section 46.013, a firearms meaning any device designed, made, or adapted to expel a projectile through a barrel by use, explosion, or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have, as an integral part, a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Orders for Emergency Protected. Code of Criminal Procedure, Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code, Section 46.02, unlawful carrying weapons. Penal Code, Section 46.04, unlawful possession of firearm. Penal Code, Section 25.07, violation of certain court orders, conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.025, warning on protective orders. Now, that written admonition that has been given to you, you can keep that for your records. You're going to stand to your left in front of our court clerk right here, and she's going to give you some instructions. Once you finish following her instructions, You'll be free to go and you have a blessed day.
Yes.
Judge, you said the probation fee was reduced as well.
$25, yes. Do you need him to have a seat?
No, sir.
Okay.
Your right thumb, 3 times.
Phillips County Court at law number 2 is back in session. The court is in session in cause number 23CCCR0048. The case is styled the state of Texas versus Ambriana Cornell Sykes. Sykes, is that your full name?
Yes, sir.
State, you have her waiver, not a waiver, but our judge's explanation. And what about,
She didn't have that.
well, she had to have that waiver.
She needs the other one.
Yeah.
I don't know where that.
Let me do this here.